113, counsel? You want any rebuttal time?
2 minutes, please, Your Honor.
2 minutes, sure, go ahead.
Thank you very much. May it please the Court, Ben Schatz, Cahill Gordon, on behalf of Mr. Basile.
Counsel, what is this statute all about? Not a strict liability statute.
Not a strict liability statute, Your Honor.
What is it?
It's a statute.
What does it require to?
It requires proof that the defendant knew that in this case, for instance, that the dog.
You agree it's knowledge is the test?
Knowledge is the proper standard, and we're basing.
Where's that in the statute itself, where it says knowledge is the test?
Well, the problem we have is that the statute is ancient, essentially. It's 150 years old. So the legislature in 1867, when the statute was passed.
Hasn't the legislature recently amended the AML, the Agricultural Markets Law, to include some sort of mens rea in provisions that follow this one?
Absolutely, and that's precisely why we think that
But it didn't amend this particular statute.
No, it didn't, and I don't think we can make anything of that sort of legislative inaction. There are a number of cases from this Court that
they amended it for aggravated cruelty, right?
Every other modern animal cruelty statute.
No, that wasn't my question. They amended it to include an element of intent for aggravated cruelty, correct?
Yes, Your Honor.
Okay. So you don't think it matters that they didn't do it here, but they did it there?
No, certainly not. I think that the fact that the modern legislature, when it is writing statutes that prohibit actions against animals, includes a mens rea in every single one of those statutes. That's exactly what the Court should look to in trying to construe what the legislature intended to do with respect to Section
353 says neglects, if the person neglects to care for the food.
That's right. There are a number of.
No intent. I mean, you can just be neglectful.
No, and I think, Your Honor, there are a number of words in Section 353 that connote some sort of mens rea, and the very early cases, even following the passage of Section 353, even suggest that something needs to be in place with respect to mens rea, whether.
So what's the purpose of Section 43 then?
Section 43 is not dispositive. Section 40.
Assuming that it's not dispositive, what purpose would it serve? Wouldn't it be totally, extraneous if we don't apply it here, where there is no stated mens rea?
No, it would not be extraneous at all, because there are a number of provisions in the AML that were passed at or around the time that Section 43 was passed that were the types of statutes that.
So when we look at a statute as a whole, we have to look at when each provision was enacted in relation to each other, every other provision. We don't assume that if the legislature wanted to change something, it would do that?
No, Your Honor, and I think especially when you're dealing with something like strict liability, where 1515-2 of the penal law says that you presume against strict liability.
Why would that be relevant here?
Section 1515-2 applies within the penal law and without the penal law.
True, but we have a specific provision right in the very law we're looking at, which is the Ag and Markets Law. Why, if we have the two conflicting provisions, why would we look to the penal law and not to the statute we're interpreting? Well,
there's a significant amount of ambiguity surrounding Section 43. Half of the statutes in the Agriculture and Markets Law contain an express mens rea requirement, so it can't be the case.
Well, then it wouldn't obviously apply to those, but what it's saying is where there is no express mens rea, then none is intended.
That is not what Section 43 says. Section 43 was in place in 1909 when Section 353 was part of the penal law. Section 353 wasn't transferred into the Agriculture and Markets Law until a number of years later as part of this large-scale reorganization of the penal law, and when it was transferred with a dozen other provisions into the AML, each of which contained an express mens rea requirement. And I don't think we can take Section 43 to mean that all of those statutes were suddenly stripped of their mens rea.
You passed over, I think, my question, because as I look at 353, it says deprives any animal of necessary sustenance of food or drink, or neglects or refuses to furnish it. So if you neglect to furnish food to an animal, it doesn't take an intent. I mean, you just aren't paying attention. And that's a violation of 353.
I think, Your Honor, I think you're exactly right. I think there is language in Section 353 that is suggestive of mens rea. The trial court.
No, I'm saying neglect. I'm
sure.
saying you're guilty if you neglect your animal. And the fact that it's an old statute, frankly, there's more animals back in those days, and they're more important to people than they seem to be now.
Right, and I think that's precisely the idea, that the jury was not permitted to consider whether or not the defendant, whether the standard is knowledge, whether it's criminal negligence, whether it's an intent standard, was not permitted to consider the defendant's mental state.
Under your analysis, throughout this provision, there are all different kinds of mens rea.
In the agriculture and markets law, yes.
Well, no, I'm talking about this.
Oh, I'm sorry, yes.
Specifically.
Yes, Your Honor, and I think that's a product of the fact that a pre-modern legislature didn't use the types of mens rea standards that we have in Section 1505 now, and that's the problem we're dealing with. And short of clear intent, evidence of clear intent by the legislature to impose strict liability, the court is required to construe the statute as one of mental culpability.
Assuming we agree that, I'm not saying we do, but assuming we agree that there are indications that there are different types of mens rea throughout the statute, which one would we settle on?
I think the best way to answer that is to look at what the legislature is doing with respect to animal welfare statutes. And every single one of the statutes that the legislature has passed in the last 2 decades or so, it requires at a minimum knowledge before conviction can obtain.
So let's say we agree with you about that. On this record, why isn't that pretty apparent? Even assuming that knowledge and knowingly is the standard, why isn't it pretty clear from the evidence here that it was knowing?
I think there's an abundance of evidence that from which a jury properly charged could have determined that the defendant didn't have knowledge that, on the people's theory, that the dog was deprived of necessary sustenance. The people's own expert, a veterinarian.
So you have to know what? You have to know.
You have to know that you're not feeding the dog enough food. You have to know that the dog is actually deprived of necessary sustenance. And the veterinarian got up, a man with 30 years of experience, and said, even I had to put my hands on the dog to know that the dog was in the state it was in.
What about water? What about hydration?
The dog was not dehydrated.
The dog wasn't dehydrated?
No.
I thought that's what the veterinarian said.
No, the veterinarian testified that everything was fine with the dog other than malnourishment. The dog was on the verge of dehydration. That was the testimony, but it wasn't.
Okay. So that shows that there's some dehydration, right?
I suppose that's right. I think ultimately, though, the question is whether or not the jury could have taken the evidence and decided whether or not the defendant knew that he was taking adequate care of the dog. And in addition to the veterinarian's testimony, the fact that the defendant was feeding the dog every day, was essentially doing the best he could. The fact that the dog was described as a dog of reasonable strength, a friendly dog, a non-apprehensive dog. The fact that the defendant testified that.
I just asked you were
Yes, Your
saying
Honor.
that the defendant fed the dog every day.
Yes, Your Honor.
Maybe I misunderstood the record, but I thought the defendant couldn't eat every day, and that's why he didn't feed the dog, or he couldn't eat 3 meals a day, he didn't have the.
That's right. The defendant testified.
He was feeding the dog sporadically whenever he ate, correct?
The testimony was that the defendant said, at times I couldn't even afford to feed myself once a day.
Right.
But at page 194 of the appendix, he said, I fed him every day, even if it was just a little bit, because at times I could only eat once a day. That's on recross at page 194. I think the idea is that the defendant was doing absolutely the best he could to feed the dog. There was testimony that he was feeding the dog every day, and there are a number of other facts from which
That doesn't preclude knowledge that he was insufficiently feeding.
absolutely does not preclude knowledge. The issue is whether or not a jury had enough evidence.
Go to knowledge that he was insufficiently.
I'm sorry?
Does it even go to the question of knowledge? The fact that, that he was giving him some food every day, is that relevant to the question of whether he knew?
I think it is, Your Honor.
Feeding him enough.
I think it is, Your Honor, because I think what it says is he knew he was feeding the dog. It's unclear whether or not he knew the dog was deprived of sustenance. He testified that he knew something was wrong with the dog, but he thought the dog had worms. He thought it had an intestinal problem, and he tried to get veterinary help for that. So a jury could have concluded that he had knowledge that something was wrong with the dog, but he was feeding it every day, and maybe he didn't know that the dog was deprived of sustenance. So I think.
Okay, thanks.
Thank you.
You have your rebuttal.
Thank you.
May it please the Court, Nicoletta Caffery for Richard Brown, the Queens County District Attorney.
Counsel, what's the test? Is it knowledge?
The test is not knowledge. There is no mens rea whatsoever in Section 353 of the AML.
Strict liability?
strict liability. Not only does 353 not have a mens rea, but Section 43 precludes the consideration of a mens rea unless otherwise specified. So taking those two statutes together, it is clear that the trial court correctly charged the jury here without the insertion of an additional mens rea that is simply not present in the statute. And as far as the knowledge, that actually would not have helped the defendant in this particular case because it was evidently apparent to the untrained observer, in fact, an anonymous caller called the ASPCA about the poor condition of the dog.
What are you saying, harmless error? Are you saying harmless error then?
I'm saying harmless error goes to a different portion of it, but there is no mens rea regardless, even if you were to insert what it actually doesn't help this particular defendant because it would be harmless error.
The provision that says or refuses, what's the mens? What's the
Refuses is refuses, neglects is neglects. We do not add knowledge, intent, or any of the other penal law mens rea. What is apparent in the statute, or the words of the statute, are very plain, very clear, very easy to interpret, and to the extent that there is any unclarity about it, which there is not, Section 43 makes clear that there is no additional proof required. And all of the actions that are delineated by...
Why do you need the refuses? You've got deprives. What do you need refuse for? What is that adding to?
It's
not some
it's adding more specific additional behavior or conduct that is made illegal.
Isn't it mental consciousness of what I'm doing or not doing and its impact?
It certainly is, but it does not require the instruction to the jury of an additional mens rea on top of it. The words refuses, neglects, deprives, torture, injure, maim, mutilate, all of those are very, very clear words.
Well, neglect is an interesting one because it seems to me usually when you're talking about someone being negligent that there's comparative negligence. So, I mean, maybe he was, as counsel's saying, not treating the dog as well as he could, but shouldn't the jury be able to decide what he's doing with what little he has, and shouldn't that be a charge in terms of what...
The charge was it had all of those words in it, and to the extent the jury needed to decide what to do, it was quite clear that the gravamen here was he didn't feed the dog.
What words did they put in? Did the judge say, and by the way, if he's unable to feed himself, that's a defense to this because this dog obviously is not as important as a human being, and you wanted to preclude him from putting in the fact that he didn't have any money. The judge says you can put that in. I mean, did the jury get to say, we're sorry the dog is sick, but, this young man was even sicker, and so you can't blame him.
It was up to the defendant to either obtain the food by using the resources available.
I'm saying, did the judge give the jury, you said, charged all of that. I mean, did the judge give the jury the type of instruction that would allow them to mitigate what is charged with neglect?
No, there is no mitigation. It is the actions, the conduct of any of those that were charged that was deprived.
So there's no defense that I can't feed myself, so I can't feed my dog.
That is not a defense. Right. That is, in fact, it is not a defense. And given the extremely poor condition of this dog, while counsel says that it wasn't apparent, it was apparent.
We can take the record for what it is, but the way I read it was Dr. Reisman, he put him on 5 out of 5. I think the word he used was emaciated, and that he was a step away from death.
A step away from death, which, regardless of the long hair, didn't matter. It was obvious anyway. It was also obvious to the ASPCA officer when he came into the backyard. He said, usually with a long-haired dog, it's harder to tell, but with this dog, I could tell. It was so apparent. Ribs, pelvis, skull, backbone apparent. And as far as the vet was concerned, he said in order to score him on the tough scale, that is when he had to put his hands on. It wasn't because he couldn't see it, but to make a determination regarding just how bad he was one step from
Getting back to the
death.
language, I know it's not necessarily applicable to this defendant, but it is not true that the whole provision lacks a mens rea or a culpable mental state. I mean, it says, or who willfully.
The statute
You have it
at the
somewhere.
end.
I understand that that's not the provision.
That wasn't the
That's not
provision.
section. But it is not true that somehow the entire provision is about strict liability.
The very end of the statute that says will or willfully does any of these other things, that's really a catch-all phrase. And so in the earlier parts of the statute, all of that context is so specific, and the catch-all has the willfully in there to where it willfully fosters any act of cruelty or furthers an act of cruelty. But even so, there's
saying that only applies to something that's not specifically identified earlier?
Yes, and this was so specific and so clear. The condition of the dog was poor. He was virtually clinically dehydrated as well, filthy. So all of the sustenance or the basic necessities apart from the sustenance also were not provided to this dog. Shelter, he was on a 4-foot line, not even able to get to the purported cinder block.
Well, what section, what part of the statute does the lack of shelter?
That is actually, that evidence was not put in for the part of the statute. It's only the deprivation or the starvation of the dog. All of that other evidence
was read to the jury, right?
Right. All of the other evidence, however, was to indicate the unbelievable woeful condition that the dog was in. It was additional evidence. The filth, all of those things that were also wrong with the dog, apart from the starvation nearly to death, showed that the defendant was not even giving him what he could for free: exercise, water, shelter, grooming, all of those.
Your adversary, I think, points out in the papers that were we to agree with you that we'd be setting a higher bar for a legal bar here for animals than we would be for children. For example, if this defendant happened to have a car and he left the dog and a child in the car, then because the statute involving the child would involve some mens rea, but this one wouldn't, he could be convicted of, starving this dog or somehow harming the dog from heat or something else, whereas he might not be convicted for the same thing involving the child.
There are scores of statutes that protect children, and certainly if the defendant did to a child what he did to this dog, it wouldn't be a misdemeanor, it would be a felony. But the comparison
But he could at least argue that, well, I didn't know that if I left this child in this condition in the car, there may be some possibility.
No, actually, the provision in the AML about leaving a dog in the car actually does have a knowledge requirement to it, same as the child endangerment. But the child endangerment statute is completely different from the statute that we're talking about. That, in both its conduct and result, is so broad and sweeping that there must be some mens rea attached to it, certainly because something that is likely to conduct, not specified conduct, but conduct that's likely to be injurious to the physical, mental, moral welfare of a child must have some mens rea attached to it, as opposed to this particular statute combined with 43. So there are very specific acts which are prohibited, which anyone would know are subject to regulation and are prohibited by law. And so it is not the same thing as the child endangerment statute, and a child certainly that was tied up in the backyard, tied to a 4-foot line, not given water, food, shelter, and was there to be eaten by fleas and flies would be, that would be a very gross felony.
Thank you.
Thank you so much.
Counsel rebuttal.
Thank you. I'd like to start with the point that Ms. Kafiri started with, which is that there is no mens rea in Section 353, that there is no mens rea present in the statute. I'll direct the Court to a decision of the United States Supreme Court that came out yesterday. It's the Alonis case. It says the fact that the statute does not specify any required mental state, however, does not mean that none exists. That's the entire idea here. We presume against strict liability, notwithstanding the fact that there's an absence of mens rea in the statute. And so here, the Court's job is to examine whether or not there's a clear legislative intent to impose strict liability. Unless the Court finds there is a clear legislative intent, its job is to construe the statute as one of mental culpability.
Well, what does it mean to have willfully at the end of this, but not anything like that term elsewhere in the provision.
I think that's instructive in favor of our position, that the statute is strongly suggestive of mens rea, even though it doesn't include terminology that we would commonly associate with section the mens rea elements in Section 1505. So the fact that the statute does include some mens rea is completely inconsistent with the idea that the statute is a strict liability statute, which is the position that people are taking in this case. And I think once you're in the realm of mens rea, there's reversible error. I think the people pounded the table in their closing argument that whether or not what the defendant did was intentional, knowing, anything like that, you have to convict if you find the dog was malnourished. In this case, it was essentially stipulated that the dog was malnourished. The dog was in terrible condition. It's a tragic situation. But the question for the jury should have been whether or not the defendant had a mens rea with respect to the dog's condition. That's the bedrock presumption of our criminal law, is that you have to have an act and you have to have a mens rea. And the United States Supreme Court has affirmed that as recently as yesterday, and that's what we're asking the Court to do.
Okay, counsel.
Thank you
both.